All right, here we are. We're starting chapter 5 from our substance abuse class of ethical and legal issues. It's a short chapter, but I really suggest you read it. Some of the ethics are a little different with substance abuse, with a federal legislation that prohibits disclosure of client information with regard to substances. You need to be very, very cautious about this, and most of you are at sites already, and most of you do have substance abuse clients. I think I would imagine all of you will have one in all populations because substance abuse is rampant, especially with the pandemic. So there are codes of ethics that relate to this section, and they are the ACA Code of Ethics, the National Association of Alcohol and Drug Abuse Counselors. They have a code of ethics, the National Board of Certified Counselors, and AMCA, American Mental Health Counseling Association. This should be a good little review for you. Remember the moral principles of counseling. Veracity is also the sixth one that's not on here, but justice, beneficence, non-maleficence, autonomy, fidelity, and veracity. Please make sure you remember these and you're studying these. This is a good review just to think about them right now. Think about your ethics. It's been a while because you will be taking that examination in the spring. So just be really thinking about, can you believe it? It's time for that already, guys? I know it's crazy. But they love to ask these questions, and I think first years just got tripped up on this a bit with the codes versus the moral principles that back the codes. So just kind of make sure that you remember that. Confidentiality, of course, is extremely important. Um, the common limits are to confidentiality are harm yourself or others, harm someone else, transmission of a communicable life-threatening disease. Client is the victim or perpetrator of child abuse, neglect, elder abuse, neglect, or domestic abuse. Valid court order, and emergency, which dictates disclosure. Now, remember how you handle these are different in different states. We have a duty to protect in Georgia, not a duty to warn, and which means basically you 1013 if you're worried about someone's safety. Um, you always use darkness to light with child abuse, meaning we had that training. I think you guys had that with Dr. Muller. Always going to want to make sure that you are reporting any kind of child abuse, even if you think there is some shred of a chance that it's happening. The court order doesn't necessarily mean that you would divulge information. The same with this life-threatening disease situation. Of course, you would always want to try to get your client with motivational interviewing, another modality to tell people, etc. So these are all just things that what they're basically saying here is, hey, this is the norm or can be the norm, but then with substance abuse, we have regulatory issues. We have different situations that protect rights further than typical confidentiality, specifically 42 CFR. 42 CFR is a code of federal regulation that prohibits you from giving any information whatsoever about the client. So let's talk about 42 CFR. So when your text was written, this brand new amendment to this regulation was not here. This came out July 13th, 2020. This is the revised part of 42 CFR. And what has not changed under the rule is here, and what has changed is under. So if you're working with substance abuse, this is something that you would need to know. So part one is the protection, part two is the protection of patient records by programs for federally assisted. Now, federal assistance means except Medicaid, except TRICARE. Most of us would fall under this bracket. So if you're working at Pathways right now, you're under 42 CFR. It is a program, it's defined as a program or any person or organization that in whole or in part provides alcohol or drug abuse diagnosis, treatment, or referral and receives federal assistance. This includes tax exempt status, so that would be nonprofits, authorization to conduct business by federal government, Medicaid, conducting services for federal government or branches of state or government that get any federal funding, any grant funding that's federal. If you work in a school district that has a free lunch program, you fall under this. If you work for a mental health agency that accepts Medicaid and TRICARE, you fall under this. If you're an employee assistance program counselor, EAP, we take that at my practice, all of these actually, then you fall under this. So it's not, so most of you, when I'm thinking where you are placed, most of you are falling under 42 CFR. So it's really important that you understand this and that you go the extra mile on confidentiality here. Sometimes in these agencies, people can loosely disclose to groups of people, or someone may come in and ask questions, and people might not be as likely in community mental health or substance use program to protect the confidentiality of the patient. So you have to make absolutely sure that you have written consent and you understand what that consent holds in place for that patient. So Part 2 has been revised to further facilitate better coordination of care in response to the opioid epidemic while maintaining confidentiality. So what has not changed? It doesn't alter the basic framework for confidentiality for a substance use disorder. Continues to prohibit law enforcement's use of substance use disorder records and criminal prosecutions against patients, absent a court order. And even with a court order, we're not necessarily, if we think it's going to do harm to the patient, then we need to get a legal consult, because that's in your text. Make sure you read this chapter. Part 2 also continues to restrict the disclosure of substance use treatment records without patient consent, other than as statutorily authorized in the context of a bona fide medical emergency. So if your client is about to die from overdose, you're going to send them to the hospital. Or if the client is in danger of harming self or others, you're going to still do that. But that's this exclusion here. It's a medical emergency. For scientific research or program evaluation, those are stats. So you wouldn't be disclosing the name or information. It would be in a statistic. So 37% or 50% of our patients have opioid dependence, or an appropriate court order. So remember, we talked about different kinds of subpoenas. Subpoena is not necessarily going to mean that you're going to disclose any information for this patient. You have to remember that could be from a lawyer, and that's not a judge. So if anything like this ever occurs when you're working, I would get your legal consult from your state organization versus your insurance. Your insurance, your liability insurance, will also give you a legal consult, but it could also flag them that something is going on. So much better to start with your state organization. LPCA gives you free legal consultation, and I believe ACA does as well. So you give them a call, and they'll walk you through it. And also, of course, supervision, consultation, and just to make that decision and see. And also your patient. Your patient may be like, yeah, sure, send it on. Let's do this consent, which is a release of information that's very specific and it's in your text. But what has changed? So the revised rule has modified several sections, and they are as follows. Applicability and redisclosure, disposition of records, consent requirements, etc. So let's make sure that we know what that is. It was in my own little research for this class that I found it. A lot of times the tough part of our field is if without continuing education in this specific area, we may not know about it. So, I think the main thing is not to be nervous about it, but just making sure you get consent. And if you can't get consent and someone's pushing you for it, then you get the consultation supervision, if you're under supervision, or consultation, or if you're not, and you get that legal consult. Make sure you protect yourself and your patient, if at all possible. So treatment records created by non-Part 2 providers based on their own patient encounters are explicitly not covered by Part 2, unless any said records previously received from Part 2 program are incorporated in the records. So this is about someone who's seeing someone that doesn't take federal funding, right? So, so they're not in the same situation. So just making sure that you understand there's different rules. Disposition of records, when a substance use patient sends a message to the personal device of an employee of a Part 2 program, which is anyone that has Medicaid or TRICARE, remember that. The employee will be able to fulfill the Part 2 requirement for sanitizing the device by deleting the message. This is to ensure that personal devices of employees will not need to be confiscated or destroyed in order to sanitize in compliance with Part 2. We shouldn't really be using our personal devices, but therein lies the issue. I mean, this happens, right? Obviously. Consent requirements. A SUD patient, substance use disorder patient, may consent to the disclosure of patient's Part 2 treatment records to an entity like the Social Security Administration without naming a specific person as a recipient for the disclosure. To allow patients for more benefits and resources, when using online applications that do not identify a specific person as a recipient for disclosure of Part 2 records. This is helping with people to get that benefits and stuff like that, which a lot of those laws have been changed. So now clients can get food stamps and things like that have a record. Disclosures permitted with a written consent. In order to resolve lingering confusion about Part 2, about what activities count as payment in healthcare operations, the list of examples has been moved into regulation text from the preamble. I don't understand this one. Disclosures for the purpose of payment in healthcare operations are permitted with written consent. Okay. Disclosures for okay, this is for payment, like third-party payers. And then we're looking about this registry to opioid programs right here. Oh my gosh, how long is this? Okay, we're not too bad. I could just let you guys read this on your own, huh? But you probably won't. Disclosures to central registries and PDMPs. So non-OTP, non-opioid treatment programs and non-central registry treating providers are now eligible to query a central registry. Okay. In order to determine whether their patients are already receiving opioid treatment through a member program. That's probably smart. So that they're not getting double Suboxones or double methadones from multiple places. Now, these opioid treatment programs are permitted to enroll in a state prescription drug monitoring program, which is the PDMP, permitted to report data. Okay, that's excellent. I'm sure that's happening a lot. Declared emergencies resulting from natural disasters that disrupt treatment facilities and services are considered now an emergency for the purpose of disclosing records to ensure continuity of care. Disclosures for research under Part 2 are permitted by a HIPAA-covered entity or business associate to individuals and organizations who are neither HIPAA nor subject to common rule. So we can now have more research open up with protecting patient information. So we're just collecting data, right? Numbers and stuff like that. Oh, ooh, what's this one? The audit and evaluation. Okay, we know that we're going to have to be audited sometimes. We're covered. Well, that's always covered. Like if Blue Cross Blue Shield came in to audit us, they would have to look at some files and make sure we're doing what we're supposed to be doing for our online files. Okay. Undercover agents and informants. Court-ordered placement of an undercover agent or informant within a Part 2 program is extended to a period of 12 months, and courts are authorized to further extend the period of placement through a new court order. To address law enforcement concerns that the current policy is overly restrictive to ongoing investigation. I don't love that. I wonder how you guys feel about that. Don't love that. Don't love that. Okay. So some exclusions to this too, that one of the cases in your book is, I think a police officer comes and wants some information. And you can say, I can neither confirm nor deny that that person is here. However, if the person has never been there, you can say that they have never been there, because if they've never been there, they're not covered under 42 CFR. But if they are there, you can say, I can neither confirm nor deny that they're here. You have to get written consent. And that written consent is pretty detailed. So making sure it has an end date, making ensure that you are completely covered. Exceptions to this rule can be in public school. Student is taken out for, let's say, rehab, but you have to think about what's going to do the least amount of harm. If we're with a written consent, yes, if you get consent, you could report it, but for your teachers and things, they really need to know that. I mean, they're out and that kind of thing. Just making sure that you're being really careful. I talked about that please make absolutely sure that you read the section on other confidentiality issues, just making sure that you understand things like we talked about, like if they had TB or HIV, getting them to report that to their local public health authority and having them take it from there and getting them um, the best thing to do is work with them to get them to do that and make sure you have some proof of that. You don't have to tell them they're in the substance abuse counseling program. Though that I mean you can protect that part. Um, so also still like reporting child abuse and things like that. But you don't have to say you don't have to say substance abuse. You can just report it. So a couple different things with TB and HIV. We're just kind of talking about that, but um, if you're in a program and the client tells you and they won't consent, um, you could let them know there has been a case, perhaps, and not tell them who. Um, also, what I said stands true. Have the person warn the people and tell the Department of Public Health, your health agency, local health organization, health department. I'm sorry. So just making sure if you can get that done, that would be ideal because sexually transmitted diseases may not be an immediate threat and not covered. So it's not really cut and dry, so as most ethical issues are not. And moving into confidentiality and school testing, another big issue, right? Um, So we also have FERPA, which is Family Educational Rights and Privacy Act. So it's very tricky with school counseling. Those of you that are there doing the clinical mental health piece for the schools are probably finding this out. And a lot of those parents need to consent to treatment, but then the age of consent in Georgia is what? So I want you to think critically about this. How would you apply 42 CFR here? Please make sure you read this section because we will be discussing this in class next week. So just kind of delve in and kind of roll over it a little bit and see what you're thinking. Maybe go to your sites, talk about it, and bring that information back to class. We can have a rich discussion together. In HIPAA, this is a good review for your test and making sure that you know how to define this. It's the Health Insurance Portability and Accountability Act, or HIPAA. It was passed in 1996 and required the standardization of records and the security of all health records. HIPAA and 42 CFR are in agreement, but they are different. And 42 CFR is specifically for substance abuse. And you want to ask your agency, how do they integrate 42 CFR with HIPAA? And see, maybe that could be something good to talk about and then come back to class and talk about it. And have an open mind. Some people in your agencies, they may not even know about 42 CFR. Like I said, it's a lot in our field, and sometimes people they do 35 CEs and they may not know about 42 CFR. So, don't judge. So, I mean, if someone had told me that right off the bat, hey, what's 42 CFR? Without me being a professor, I may not have known. So just you may want to note what your agency or school is doing, or if they are aware of that, and just make note of that. So drug testing can be really controversial. Okay, So there's guidelines for drug-free workplaces, school drug testing. There are actual at the internet resources at the end of the chapter about that. Um, the current federal stance on drug testing is weighted toward do it, whereas organizations like American Civil Liberties Union oppose the way that drug testing is implemented. There are multiple court rulings on this topic, and so we're going to just take each one of these areas and discuss pre-employment testing, random testing, etc. So let's start with pre-employment testing. That's often a requirement of employers. Um, So this has to be part of the whole battery for pre-employment testing, like part of your process to get hired. So it can't just be something they randomly do. It has to be part for all employees in a uniform standard. Random testing. So random testing can be, sorry, I'm having such a hard time today. It is virtual learning day at home. And we got a new kitten named RBG. So the kitten is on my book, and my kids are doing virtual school. So, full disclosure, I am trying to do these lectures with multiple. I wish I could show you all the kittens. I'll take a picture and show you guys. Okay, so reasonable suspicion testing. This is very subjective. It probably needs to have evidence of some sort, um, because you could get sued, right, for just singling someone out. Post accident, um, you have to have a policy. If there's an accident, that you will automatically drug test. So all of this has to be written into the contract when the person starts working at the place of employment. So treatment follow-up testing, that is another ambiguous area. They may have a policy to test people who return from drug treatment. It can also be a real issue with privacy. It can be stigmatizing. Usually only high security and public safety would have a really stringent policy for this. In drug testing in schools, in June 2002, the Supreme Court upheld the use of random drug testing for secondary students participating in competitive extracurricular activities. Schools can conduct random testing for cause, evidence of drug use, or possession. It should be noted that there was a study that found that drug testing had no impact on the rate of drug use in schools that conduct such testing compared with schools that do not do drug testing. So that could also be quite controversial. Pay attention to how you do your notes. Make sure they're brief but factual. Know what your agency expects of you. What do they want you to report? And also, how can you keep the best interest of the client? I know with drug court, I was very cautious. In fact, they would question me at times about um, information and that my notes were very brief. And I said, my notes are brief because I want to be able to protect my clients. I bet you guys are wondering if I'm ever going to get through this. Oh, the virtual day. I tell you, we have one virtual day today and again in November 2nd, which is probably one of the worst times for me with school and everything that we have going on right around that time. Yeah. So my kids are here and this is my day. My Monday all day is my record lecture day, catch up on LaGrange College, everything. So here I am trying to do this for you guys. Just make sure you read over it. Of course, no discrimination at all. Diversity and ethics are really important in substance abuse. Any bias will impact fair and equal treatment. There are multiple potential ethical conflicts that you have to keep in mind. Make sure you're consulting the codes and utilizing, remember, the ethical decision-making model. There are more than one of these, but this is one of the main ones, Forster, Miller, and Davis. And this would, when you're actually practicing, It's really, really important that you never forget this model, even when, you're on your own, especially when you're on your own and not under supervision. I consult constantly and I am consulted constantly. It is extremely noteworthy on page 92 to make sure you are practicing in your scope of practice. I would not see a psychotic client. Now, if someone is struggling with some substance use, and it's a part of their treatment plan, but it is not impacting their day-to-day life in any way, or you don't think they're in danger, sure, that can maybe be a treatment goal for you that you're able to work with them on. They're highly motivated, they're taking action. But if you're going to diagnose someone and they're actively addicted, especially to opioids or something else similar to that, or alcoholism, it would be really most ethical for you to try to find someone who has extra training in substance abuse. I have a certification in substance abuse, and there's only a couple of us in town that hold those certifications. So we're going to have training in how to diagnose, how to assess, how to diagnose, and what to do with that client. Scope of practice is a real issue, so making sure that you have some extra training in substance abuse. I really think you may not have a certification, but extra training certificates to show that you have had enough training, you've had this course. What kind of training have you had to make sure that you are working within your scope of practice? Always keeping in mind the best interest of the client, always making sure that you are doing the best you can for that client and making sure that you are referring to the appropriate programs, not using the same program all the time, and you're an advocate for your client. Managed care, when you start taking insurance, managed care is an issue for you, and you'll have to work with those insurance panels, HMOs, etc. The insurance panel may not cover alcohol treatment, right? So often we want to get paid and we want to be able to help the person. So you also could have other diagnoses, and you have to just use the ethical decision-making model. But I would say it's not that difficult to get a depression or anxiety disorder out of with a substance abuse. It's not terribly difficult for someone to meet the criteria for PTSD with substance abuse. So as long as you're backing up what you're doing, you could always make that a secondary diagnosis. It's not going to be the end of the world. I mean, so just really, I know this sounds over the top and difficult, but there are ways to do this and to maintain ethical standards and make sure you're not lying or being unethical in some way, as long as you know the client, right? Because it's very hard for me to see that if someone's going to present with a substance use disorder, that's not going to have a co-occurring issue. That's going to be pretty rare because usually if they're reporting for that, they're going to have other issues in their life that would cause them to have depression or anxiety or something of that nature. So then make sure you read through the application of confidentiality regulations as well. We're going to talk about 42 CFR in class. We're going to have some talks next week. So do that in 28 minutes. I'm so sorry for the disruption.